turn it over. Right, we are now live and recording. Hear ye, hear ye, hear ye, all persons having anything to do before the Honorable, the Justice of the Massachusetts Appeals Court, now sitting virtually within and for the Commonwealth, draw near and give your attention, and you shall be heard. God save the Commonwealth of Massachusetts. Court is open.
Morning, Council. This is a single justice petition 2020 J0542. It's a petition from a preliminary injunction entered in the Superior Court. Mr. Corner, I think we're going to hear from you first. Is that right?
Yes, Your Honor. Thank you. I do represent the petitioners.
Before you start, let me just say I have a lot of questions. Many of them are very basic, so don't be surprised if I interrupt as you go. But why don't you? I've read all the papers. I think I understand the case pretty well. Why don't you start and then we'll jump in.
Well, thank you, Your Honor. Again, I'm for the record, Mark Corner for the petitioners, John and Sarah KADZIELSKI, as trustees of KG Realty Trust. Your Honor, I would again, as you noted, this is an appeal under the first paragraph of 231-118, a request for interlocutory relief from a preliminary injunction order issued by Plymouth Superior Court, enjoining my clients from using two outdoor fireplaces on their property in Hingham. At first blush, Your Honor, this injunction may appear to be of little consequence. Clients are required to stop using an outdoor fireplace. I'm not a person who's prone to hyperbole, Your Honor, but this injunction is the functional equivalent of enjoining my client's use of their living room. This outdoor gazebo where the fireplaces are located is my client's primary living space. It's where they spend a substantial amount of their family time with their two young children, and this fireplace provides the sole source of heat for this area. They do use the fireplace both during the winter and during the summer, and they live near a freshwater lake. So part of the reason for using the fireplace is to repel mosquitoes during the summer. This is a
well, it doesn't enjoin them from using their living room. It doesn't enjoin them from using the space at all. It enjoins them from using the fireplace, which pours smoke into their neighbor's yard, right?
That's the assertion is that it pours smoke into the neighbor's yard, Your Honor. There is no. If
it did pour smoke into the neighbor's yard, as indicated in the affidavit of the neighbors, as described in the brief, it would be a nuisance, right?
In theory, Your Honor, smoke could be a nuisance, but there is not a single reported Massachusetts case that I've ever seen.
If the smoke was so thick that they could not use portions of their house, that their children had to sleep in the basement, that's a private nuisance. Yes or no?
If that were true, yes, Your Honor.
Okay, so isn't the problem here really that there's a dispute over the facts?
Yes.
Okay. What happened below? Was there an evidentiary hearing?
No, Your Honor.
Did anyone ask for an evidentiary hearing?
No, Your Honor. It was
done entirely on the papers?
That's correct.
Is there a transcript of the hearing?
Not that I'm aware of, Your Honor. It's certainly not part of the record.
So, well, but you're the appellant. And the standard of review is what?
The standard of review,
right?
It's de novo review based on plenary review of the record.
No, it's abuse of discretion, I believe.
Well, I believe, Your Honor, I believe it would be abuse of discretion had findings of fact been made. Findings of fact were not made here. So I believe you conduct plenary review of the record to determine whether the record was sufficient.
Where do you say that, counsel? That's important to me. Where do you say that in your brief? I'm looking at it right now.
It's at page, Your Honor. It's look at the wrong petition. I'm sorry, Your Honor. It's the Jetline Services case, Your Honor, among others, and it appears at Page 2, bottom of page 2, Jetline Services versus Selectmen of Stoughton. It also, that standard of review also appears in the
Hang on for one moment. I want to pull that out. So, so your contention is because there were no findings, it's de novo review.
Yes, Your Honor.
Let me just, Attorney Marino, is he right?
I don't believe that's what that case stands for, Your Honor. I don't believe that's the proposition
Well,
of that case.
what do you think that my standard of review is then?
I think it's an abuse of discretion.
And do you cite some cases in your brief on this? I have to tell you, I just assumed it was abuse of discretion, guys. That may be my error, but I was very focused on the fact that there were no findings of fact, which is what I came in to start asking about.
We do have that in our papers, Judge, Your Honor. It's in the beginning of the argument. We cite 4 or 5 cases, all saying that it's on a petition like this for a grant or denial of a preliminary injunction. It is an abuse of discretion standard.
Your Honor, if I may.
Even where there are no findings whatsoever?
The cases don't distinguish whether or not there are findings or not.
All right, let me just pull down Jetline. Give me a moment.
And Your Honor, if I may, not to interrupt, but the Aspinall case, Aspinall versus Philip Morris case, cited by the plaintiffs at page 389, lays out the standard of review.
Okay, so which do you want me to read, Jetline or Aspinall?
Well, the Jetline, I'm sorry, Aspinall, which is a SJC case, cites Jetline, which is an appeals court case, and says the authority of a single justice on petitions arising under 231, section 118, first paragraph is, and I quote, plenary, with the result that the single justice's order will be reviewed by a panel on appeal as if an identical order from the trial judge considered the matter in the first instance.
That doesn't sound right to me. My authority is not always plenary. Many times my authority is subject to, it's an abuse of discretion standard of review. So you may be reading from something that's a little different than what I've got. My understanding coming in, sitting down today, is that on a preliminary injunction entered by a lower court, my standard of review is abuse of discretion or other error of law. It may be that in the peculiar circumstances where there are no findings, that standard of review is different. Which case would you like me to pull down, or should I just wait until after we're done with argument?
I would refer you to Jetline, Your Honor.
Okay, hold on for a second then.
Sure. It's at page 646.
I see. In most cases, based on the deference normally accorded to determinations by the judge who heard the matter in the first instance, the single justice will decline to act on an application for relief under Chapter 231, Section 118 that does not disclose clear error of law or abuse of discretion. What Jetline says is I have the authority, not that I have to. Right?
Yes, Your Honor.
Okay.
And to that point, Your Honor, I would say in this instance, first of all, I think under the record here, I think you could find, based on your review of the record, and given that there's an absence of findings.
How can I find, based on the review of the record, that there's an abuse of discretion? Let's leave aside your legal arguments for a moment, which I'm not, which you can try to persuade me on, but you're going to have trouble. How can I decide on a review of the paper record that the judge abused his discretion here? I have an affidavit from the plaintiff, Mr. Ilios, or is it Paschalis Ilios? I'm not sure whether it's two last names or one. On many occasions, we've been forced to abandon our plans due to the unbearable smoke and odors. The smoke is so severe in certain rooms, including the living room, study, guest bedroom, and child's bedrooms, that it is unbearable to remain in those rooms. If we stay in them for too long, we begin to feel ill and nauseous. The smell of smoke is so strong in our children's bedrooms that we have to frequently launder their covers. We have, and it goes on, right? I mean, if those facts are true, I can't see how this is not a private nuisance. What do you say to that?
Well, Your Honor, first of all, there is contrary evidence from my client.
Actually, very interestingly, when I read your client's affidavit, I didn't see him really controverting the fact that there are occasions where these things happen. He didn't address those things in his affidavit.
Didn't address that Your Honor, what he stated is that it's basically an impossibility for the level of smoke that the Ilioses are complaining about to be generated from their fireplace. They have a fireplace that
actually, interestingly, he didn't say that. He suggests that. He says we're 120 feet away. Our fireplace is not that large. It's 21-foot smokestack. He says a lot of things from which one might certainly infer that that's what he's trying to say, that it's impossible, but he never says, we don't have smoke that billows out like this. He just doesn't say it. And I found that interesting.
Well, Your Honor, first of all, he's certainly not going to be in a position where he's going to be able to controvert firsthand whether there was smoke coming onto the Ilios' property.
How can that be? They've been involved in a dispute for a year, and he's 40 feet from their property line. When he's using his fireplace, he can walk to the edge of his property line and watch where the smoke goes. How can he not say they're exaggerating or they're not telling the truth?
Oh, I think he said that. I think he said that pretty clearly, Your Honor. If he didn't, I certainly argued it, and I will argue it here. This is an exaggeration. He is not telling the truth. He has stated that Mr. Ilios in his affidavit has stated there is daily use of almost daily use for up to 12 hours a day. That is nowhere demonstrated in any of their.
Up to 12 hours a day, I don't think. He says, I think the lawyer may have said that, but I don't think he says. What they do say is that your clients used the fireplace 87 times in 2020. Is that true or not?
I believe that. I believe that's true.
Okay, so some of this is accurate, right? The fireplaces are used. That's a third of the days up through November.
It's about 100. They have measurements of. They've identified measurements of. I believe it's 117 out of 477 days.
Well, but 87 times in 2020, not so much in 2019, but a lot in 2020. That's what I counted anyway.
That's certainly the assertion, Your Honor.
It's your client's property. So as long as they're not so substantially interfering with the use of their neighbor's property, they can use their fireplaces as often as they want.
Sure. And I should note, Your Honor, that on 4 of the occasions that Mr. Ilios identified my client as using the fireplace, my clients weren't even in town. That is in Dr. KADZIELSKI's affidavit.
Well, actually, he says that some of the times when they measured air quality indexes, we weren't even in town. So we couldn't have been using our fireplaces on these days where they say the air quality index was.
I believe that was one occasion, or that's January. That's the June 19th, 2019 issue. I believe the dates. The two or three other dates where Dr. Ilios indicated that
I missed that. That's actually interesting to me. Where does he say that?
Where does?
Because that directly contradicts the other affidavit, right? If there are instances where they say they were using the fireplaces and your guy says we weren't even in town, That would be interesting to me.
Your Honor, that would be a paragraph 25 of my client's affidavit, which appears on pages 102 and 103 of the record appendix. I'm sorry, 102, yes, 102, 103.
Yeah, well, that starts with the stuff about air quality, and then there's one date on which they complained about our having a fire, but we were actually watching their home that day because they were in Israel, right?
Correct. Yes.
Let me just see if I can match that up a little bit. That's one day. I don't know if that really that matters so much. What do you so you understand my dilemma, right? My dilemma is there are no findings of fact.
Yes.
And it appears to me that this is a case where there's really a debate over the facts.
That's correct.
And you suggest to me that I can do this on the papers, and I'm not sure I can do this on the papers any more than perhaps it should have been done on the papers in the lower court, given the sort of what appears at least to be some dispute over.
Sure. Certainly factual disputes, Your Honor, factual disputes upon which the plaintiff has the burden of proof.
But as to which they've submitted an affidavit, you didn't ask for an evidentiary hearing, right?
Well, Your Honor, this was a. Did I ask for an evidentiary hearing? No. This was returnable on an order of notice that occurred over the Thanksgiving holiday, and that we received notice just before Thanksgiving. The hearing took place on December 2nd over Zoom. I have done lots of injunction hearings over the year, and rarely have there been evidentiary hearings on a preliminary injunction in my experience. The court, it was returnable on pursuant to an order of notice over Zoom. So no, I did not ask for an evidentiary hearing.
The difficulty is that you say rarely are they done on an evidentiary hearing. Maybe so. I've done lots of preliminary injunction hearings myself, and I can say most of the time they're not done with an evidentiary hearing. But this one, it seems to me, screams out for an evidentiary hearing because the parties are literally competing over the facts. You have an argument about exhaustion of administrative remedies. I'll hear you on that, but I will tell you right off the bat, it seems to me that you will find no case that says that whatever the zoning laws of Hingham say, that they can change the basic common law of nuisance or somehow supervene the common law of nuisance.
Well, Your Honor, to that point, the assertion here is this is a commercial fireplace. This is not a commercial fireplace. This is a fireplace that was constructed on residential property pursuant to a building permit.
But who cares? I mean, I'll accept every single fact you say. It's not a commercial fireplace. If the smoke is as bad as is described in the plaintiff's affidavit, it's a private nuisance. And if it's a private nuisance, the fact that there was a permit to build it doesn't matter. I mean, you can get a permit to build all kinds of things and use them in a way so that they substantially interfere with the use of the neighbor's property. If so, I don't think the permit can supervene, as I said, the law of private nuisance. Do you have a case that suggests it can?
I don't have a case that says that, Your Honor, but the fundamental assertion here is that my clients are that fundamentally a fireplace is permitted is permitted in the town of Hingham and, to my knowledge, throughout New England.
There's no evidence. Since Hingham was first settled in 1635, fireplaces have been used, and they've spilled smoke into the air, probably 21 feet above the ground. So it is somewhat questionable whether that truly can affect the interferences with a neighbor's property that's 120 feet away that are claimed. I understand that, but that, it seems to me, is the factual issue that I don't have any findings on.
That's correct, Your Honor. And first of all, you will find, not as far as I can see, not a single case where a wood fire from a residential fireplace gave rise to a claim for either nuisance or trespass. And I can cite you a case where the contrary was true. actually a case out of Iowa, which is not in my papers, but it's a case Hafner versus Clark. It's 795 Northwest 2nd 99. It's a case out of the Iowa Supreme Court, and it's a case, as you point out, it's a case that turned on its facts, but under that set of circumstances,
what was the site? 795 Northwest 2nd.
795 Northwest 2nd 99.
And it says.
And it found that the operation of two wood-fired furnaces did not, in a residential house, did not constitute a nuisance.
But it didn't say, as a matter of law, you can use your fireplace however you want.
No, it didn't. And we're not making that assertion.
Well, yes, you are. To the extent you're talking about exhaustion of administrative remedies and the fact that there's a permit to build, you are making the law.
Well, I mean,
and you're suggesting it when you say to me, there's no case that's ever said this. You're suggesting that somehow that makes this sort of unprecedented and not legally correct. And well, I can't see that.
Your Honor, again, this is the plaintiffs are asserting that this is a commercial fireplace, which is not a permitted use, and if that is not a permitted use, then their obligation is to challenge that use through the town. I don't believe it's a commercial fireplace. I don't see that that's an issue. But if that's their assertion,
I don't think that they could go to the town and they could say you shouldn't have permitted this. But they can also go to the Superior Court and say, we're being smoked out of our house. We can't use it. All right, let me hear from your brother a little bit, and I may well come back to you, okay?
Thank you, Your Honor.
Counsel.
Good morning, Your Honor.
Isn't this a dispute over facts, and didn't we need to have an evidentiary hearing?
No, Your Honor, we didn't need to have an evidentiary hearing, in part because the defendants never asked for an evidentiary hearing. And there's not a dispute of the salient facts, Judge. There is no dispute. There is record evidence of specific readings on specific days, including an affidavit from Mr. Wade. This is record 67, paragraph 13 and 16. That in my client's house, on a date that they were burning the fire, the reading inside the house was a 51 for PM 2.5. And the standard, if you look at 13, above 35 is deemed to be unhealthy.
So I don't doubt, let me accept everything you just said. I don't doubt that there are occasions on which the fireplace gets used and there's a billow of smoke that becomes unhealthy. Because, sometimes my neighbors burn leaves in the backyard and it billows smoke and it becomes unhealthy. It might even get into my house. But we don't file a lawsuit against our neighbor for burning leaves. And so the problem I have is even accepting, where is it that Mr. Wade says that the readings were sustained for a lengthy period of time? Let's say that there were hours, say over an hour of these high readings. Is that in Mr. Wade's affidavit?
It is not, Your Honor.
Right.
But your neighbor though burns leaves 3 times a year, 5 times a year. This is 1/3 of the days of the year.
But are you suggesting to me, counsel, that on 1/3, on 87 days, that smoke came into your client's house?
No, but I would suggest on 87% of the days that they burn the fire, my clients can't be outside. The smoke gets so bad, their kids
really?
Can't breathe.
Because the wind is always blowing due north in that part of the world.
Your Honor.
No, counsel, I'll tell you that's not. Okay, because I happen to live close enough so I know exactly how the prevailing winds blow. Your house, your client's house is almost due north of the defendants, right?
Yes.
Okay. I will tell you that the prevailing winds do not blow due north in that area nearly 100% of the time. So they used it 87 times, but the smoke did not blow into their house. I'll take judicial notice of that on 87 occasions.
And we're not claiming it does, Judge.
Well, you suggest that it does, and you just said that it did.
No, what I said is they can't. Yes, the smoke enters their property virtually according to my clients, according to their affidavits, the smoke enters the property virtually every time. And I don't know if it's because there are trees in the neighborhood. I don't know why, but those are the facts that I'm being told, and those are the facts that are in the affidavit. Now, again, the trial court could have abused its discretion by I don't know how the trial court abuses its discretion by following the facts that are in the record that are not disputed. Your Honor, unless
No, I'm thinking about your argument because I don't really disagree that many of the facts that you put in your affidavit were not directly contravened.
And the law is, the parties don't disagree on the law either. That's why there's no abuse of discretion. The law is pretty clear. The law is pretty standard. I think Your Honor has captured it today. And the facts are not disputed. The readings are not disputed. The amount of time they're using.
But the readings aren't helpful because they're, at least to me, they're not particularly helpful. They may have been helpful to Judge Pasquale, I don't know. But the readings, the fact that you have isolated instances where the smoke billows to the point where it is considered, or it crosses a health threshold is not surprising to me. As I said, if somebody's burning leaves in the next door yard and the wind blows in a particular way, and that's true, and it's been true of fireplaces, I suggest, as well, for hundreds of years. And what you're saying is this is different in kind.
Because of the severity and the pervasiveness and the two fireplaces, the proximity to the property, there's a lot of factors. It's the penumbra.
They're 120. Is he right that it's 120 feet away?
No, I think it's 41 feet from the property line.
41 feet from the property line, 120 feet from the house. So to the extent you're talking about readings in the house or the concerns with where the children sleep, we're talking about 120 feet or more, right?
I don't know if that's in the record, Your Honor. I've heard counsel argue. I don't remember seeing in the record. It might be, and I can't sit here and say one way or another. I apologize for that. But
seems to me it's something you should know.
Maybe I should, Your Honor. And again, the fact is undisputed, though, that the children can't sleep in their bedroom. The fact is undisputed that Miss Eloy has been advised by her doctor to avoid smoke-filled environments.
I probably should put on the record. I noticed that maybe her maiden name is Englander. There's no relation whatsoever. Okay. So basically your position is, look, we put all this stuff in the record. They didn't ask for an evidentiary hearing. They didn't really contravene the facts that we asserted. On those facts, there's a private nuisance. There's no abuse of discretion of the trial judge in granting the injunction.
Correct. And Your Honor, we haven't even gotten to the trespass, for which there's never been an argument. There's really been no dispute that this constitutes a trespass. There is smoke, there is ash that's generated by this that winds up on my client's property. No dispute of that. That's a trespass. That's an independent basis for the trial court to have awarded the injunction. And you don't hear anything about that.
If you get an injunction against the fact that smoke from a chimney 21 feet high is a trespass, then how does that prevent anyone in the Commonwealth from filing a lawsuit over smoke that crosses the property boundary?
I'm not, in this particular instance, I was referring to the soot and the ash that was coming out. And typically
smoke comes with soot and ash to some degree, doesn't it?
Yeah, but look, I use my fireplace. My neighbor uses theirs. It's the frequency of it. And typically I don't find ash and soot on my cars after I use my fireplace. I don't find it all over my house. I don't find it on my neighbor's house. It's not covering my lawn furniture. And I think the average person would experience that. So there is something unique and different about this. Again, we're not challenging whether they had the right to build the fireplace.
Counsel, what do you say to his point that he has uncontroverted affidavit that there's so much soot and ash on their patio that they can't use it or they need to clean it regularly? Why isn't that a trespass?
Well, they would need to demonstrate that came from my client's fireplace. My client's, it's undisputed that my client uses only kiln-dried oak, which does not generate soot and ash. They use it for cooking. That's why they use it. And part of the and among the reasons why they use it is because of its low smoke generation. And you'll see photographs, Your Honor, in the record of my client's children making s'mores in front of the fireplace, which can hold a fire of no more than 3 feet, which is entirely consistent with what's permitted in the town. It's also, you'll also see in the record that while there's a lot of concern about being exposed to smoke, you'll see the plaintiffs amidst clouds of smoke in their own yard. And in fact, there is a photograph that of children making s'mores in the fireplace. At the same time, you can see in the background Mr. Ilios at his barbecue and amidst a cloud of smoke. So the fact that
when you say that's in the record, that's a photograph that you guys prepared?
It is, Your Honor. It's
very hard to, on appeal, to see these with any kind of acuity.
Understood, Your Honor.
The record's just not good enough.
Yeah, you'll see it at pages 140 to 143. 143 is particularly, you can see it's a very substantial cloud of smoke coming from the Ilios property, and it's at night. And if you look at page 127, and again, it's not a particularly good picture, you'll see 2 children whose faces are blacked out making s'mores. And in the background, in the upper right, this is page 127, you'll see I believe it's Mr. Ilios barbecuing amid a cloud of smoke.
Mr. Marino, I think you submitted a video along with of smoke coming from the house of the defendants. Is that right?
Yes, there were 4 videos on that drive.
Yeah, I don't think we've got it. What do you say to his videos, counsel?
They show smoke leaving a fireplace. It doesn't show smoke coming onto the plaintiff's property. And I think there's an issue here, Your Honor. But yeah, there isn't even correlation here between the elevated AQI levels, much less any causation here. There's no, my client's expert indicated, as you've pointed out, that there's simply no evidence of extended exposure. 24 hours is required under.
No. 24 hours isn't required. 24 hours is, you're talking about like standards for environmental protection, but 24 hours isn't required to determine whether something's a nuisance.
Well, no, sure. But you will see that these are issues of very short duration. Each of the instances where AQI data is presented, one of which again was a date where my clients weren't even in town, are instances of 10 to 20 minutes.
Haven't they demonstrated causation by their affidavits, which say, no. Well, let me finish.
Oh,
which say,
sorry.
It's funny. I mean, this is we're having, because you're suggesting I should do this de novo. I'm having a little bit of a de novo argument. I'm not at all sure how I want to handle this yet, guys, I have to say. But haven't they demonstrated causation by putting in their affidavit, we observed smoke billowing from their fireplace 87 times in 2020, and there's smoke in our house, and the smoke is coming from their house into our house. That's enough, right?
I don't think they've said that, Your Honor. I don't think they've said that. They've said that there is smoke,
but I think they have said that.
I believe you will find it. There have been. I know this isn't a matter of record, but there are other fireplaces that generate smells of smoke when my clients aren't using it. So the fact that there's smoke doesn't mean it's necessarily coming from my client's property.
There aren't a whole lot of houses around.
No, there aren't, but there is a
plaintiff's house is the northernmost house in that group, and the next thing along is the Hingham District Court.
That's right, but on the others,
so there aren't a whole lot of other places for smoke to come from.
And on the other side of the lake, you'll see there's a big development where fires are burning from time to time. Look, there's
not a big development on the other side of the lake. I mean, if you're talking about I think there's a mobile home park over there, and that's a good, I don't know, 400, 500, 600 feet at least, maybe more. A couple football fields at least.
Okay.
That development that they're in is fairly new.
Yes.
And I've looked at you gave me the Google Maps of it, so I'm able to look at it.
Sure.
And as I said, I'm somewhat familiar with the area. Okay. You know, it's an interesting problem, right? Because at one level, what's being complained of is something that's been going on in this Commonwealth, like I said, since the first settlers landed here. They're burning wood to keep themselves warm. That throws off smoke. On the other hand, as I said, if the smoke is as is represented in the affidavits of the plaintiffs, it's private nuisance, and your client needs to stop because he's interfering with the use of his neighbor's property, and he can't do that. There have been suggestions that a better way to handle it would be to have a gas fired fireplace, and that would eliminate the problem. I understand your client says, I don't want to do that, but he cannot interfere substantially with the use of his neighbor's property. He has no right to do that. And they need to understand that. I read the affidavit from your client. I understand his point of view that he's been careful and that he has been attendant to wind conditions, which way the wind is blowing. And that's good. I think I'm going to take it under advisement and think on it a little bit more. Is there anything more, Attorney Marino, that you want me to think on?
No, Your Honor. I would just say, based on the standard of review and the facts before the trial court, it was not an abuse of discretion for the trial court to find, based on the undisputed facts, that this creates a nuisance.
Isn't he right under Jetline Services that I have the authority to review de novo?
I do. I think you have the authority to do so, Judge. I'm not saying you don't, but the case doesn't say you have the authority to do so because there's been no findings or facts, or it doesn't stipulate why or how.
Or at least doesn't appear to say that, right? But there have been no findings of fact, and this is a case where the parties are diametrically opposed, it seems to me. You say no, and I understand why you say no. I understand why you say no. And I want to think on that, and I think, frankly, I have to look at it harder. But they've identified some instances where your client has clearly overstated things.
No, Your Honor, they haven't. If you go back and compare those paragraphs, the dates they say, oh, on paragraph 25, oh, we weren't there on September 21, we weren't there on November 9th, those aren't dates listed in my client's affidavit. My client's affidavit is not inaccurate. And I would also direct the court's attention to the supplemental appendix that was before the trial court that we handed up on the day of the hearing. We emailed it to the court, where the EPA says, it says exactly, the effects have been, it talks about particles smaller than 10 micrometers in diameter can cause and aggravate a number of health problems and have been linked.
What you're suggesting, I understand that, I get it. But what you're suggesting is that ordinary use of fireplaces can be enjoined. I'm not going to say that.
And I'm not asking, Your Honor, this is a very fact, a nuisance is always going to be very fact specific. And these people are using it with such a frequency that, and the effect of it, the smoke is billowing into the client's property on those times. The videos show it. The effect of it is,
he says the video only shows it coming from your fireplace, not where coming from their fireplace, not where it's going.
The videos are my clients on their property, and you see the smoke billowing towards them. I disagree with the characterization of the videos.
Unfortunately, I am not certain I have the videos, and there may be a request coming to you folks to get them. My clerk tried to find them yesterday, and indicated that he couldn't. Now, this is not an uncommon problem, okay, where we don't get this kind of material from the lower court without asking. So it's not your problem. I understand it's in the record that was. Did the judge view them, by the way?
He didn't. I have no idea one way or another whether the judge actually.
You're right, and I don't know that he he had not had my materials before him at the time of the hearing, so I'm not sure what he had. It doesn't. None of the stuff that I filed appears on the docket, which is troubling.
He did not have your materials before him at the time of the hearing?
I emailed according to Judge Pasquale. I emailed the materials to the clerk the day before the hearing. I confirmed with the clerk that they had been received. Judge Pasquale indicated that he had seen only a small portion of the materials at the time of the hearing.
What was the timing of the filing versus the date of the hearing?
It was filed. We received notice again. I responded to Mr. Marino's letter of basically
Looks
telling
like
us,
their date on their pleadings is November 16th. Does that sound right?
that sounds about right.
So did you receive copies of his papers on or about the 16th?
I believe it was later than that. I believe it was the 19th.
And the hearing was on the 2nd?
Correct, Your Honor.
Which was the Tuesday after Thanksgiving?
That is correct. And I note that we didn't receive.
Did you try to seek a continuance of any sort so you could get your materials in more than the day before? So your pleadings were filed on the Monday the 1st?
Correct.
Did you seek a continuance?
No.
Is there anything else that you want me to hear, counsel, Mr. Cormer?
Well, Your Honor, again, we have been talking about whether this is a nuisance or not, and I've stated the reasons why it isn't. As far as this being irreparable harm, as you pointed out, this is the fires have been going on for since time immemorial, and these fires have been going on since at least as far as the record indicates. These fires are dating back until back to July of 2019. My client, and there were some discussions between my client and the Ilioses about possible mitigation. Which, by the way, those have as recently as last week, I'd follow up with the plaintiff about that. But the fact of the matter is that this condition that suddenly requires injunctive relief is persisted for some 17 months or so before this lawsuit was filed, including 2 months.
I mean, yeah, that's not a particularly powerful argument for me, it seems, because first of all, they say that the use has increased substantially during 2020, and also, I don't blame them for trying to work it out with their neighbors before they go to court, right? That's what we would want them to do.
Exactly, Your Honor. And I made when I received Mr. Marino, my clients received Mr. Marino's letter, which was dated September 1, and said, get back to us by September 11, or I'm filing suit. I responded and say, okay, well, I'm representing him. I will accept service, and please let me know if you'd like to discuss this matter, or words to that effect. It's in the record.
No, well, but that's not, Again, can I just ask, which house was built first, and when was it? You say this has been going on since July of 2019. Is that when the fireplaces were erected?
Well, no, Your Honor. First of all, I believe, to your first question, I believe the Ilios' house was constructed first. The outdoor gazebo was constructed, I believe, after the house, but in conjunction with the house. And back in I believe in 2018, and you'll see some correspondence in the some text between the parties, and there were some discussions about the fireplace, but inviting the Ilioses over for I believe for Thanksgiving was one issue, and another time Mr. Ilios was there, was sitting sat with Dr.
Well, I would
KADZIELSKI.
certainly hope that we can get back to that neighborly approach to life at some point. But right now, they don't appear to be in that position. All right. So 2018 was when the fireplaces were built?
I believe so.
Mr. Marino, is that right?
I think that's, yes, Your Honor.
So why
So they were
were
finished.
they just not being used in the same way in 2018 and 2019 that they were being used in 2020?
The use was not extensive in 2018, and they had some conversations in 2018. The use became worse in 2019, and that's when they're having conversations. That's when my clients went out and put up, said, hey, we'll pay for you to convert this to gas. They said no, but all you have to do is put up some pine trees that'll act as screening, and that'll prevent the smoke from coming. My clients went out and spent $20,000 to put up these pine trees to act as a natural screen to prevent the smoke from coming through, and they waited some time, and then that didn't work. And so at the beginning of 2020, the usage is increasing, and we started to try to negotiate with them. There's no latches here, Judge. We complained when they started to build it.
I get it. And I'm not sure it would matter that much, honestly, because it's a continuing nuisance. 20 years maybe, and trespass, you say. Okay.
But again, Your Honor, where I was going with this, and I apologize if I got off track, but this is, there's the issue here. The timing relates to whether there's actual harm and whether there's irreparable harm. And if there's not a single a single stitch of evidence that suggests that there's any medical issue, that from certainly any credible evidence that suggests that there's any medical issues here.
Really? He says, I can't remember who it is, but somebody who comes there regularly, or maybe even somebody who lives there. I think the wife.
The mother-in-law who lives in Israel, according to Mr. Ilios, had some sort of a respiratory issue.
Does the mother-in-law live in Israel, Attorney Marino?
Your Honor, I have no idea. That's not in the record. I honestly have no idea.
Why are we hearing about the mother-in-law's issues with coming if she lives, on the other side of the world?
Because I don't know if that's true first, but the mother-in-law cannot visit. And when she visited, she got ill and she cannot come back. Their parents cannot visit them. And again, I'm not stipulating it's true. It's not in the record. I don't know where that fact that Mr. Corner just mentioned is nowhere in the record. So I don't know if it's true or not. But their parents can't visit, and that is a fact. Miss Ilios is ill, and that is a fact. And when the mother-in-law visited last time, she became ill and could not stay there. That is a fact, and that is in the record as well. Because of the smoke.
And she may have been ill, but there's nothing in the evidence in the record that's certainly nothing competent other than Mr. Ilios saying, well, she got sick because of smoke.
I would think that's competent. Mr. Ilios says, my mother came, there was smoke, I observed the smoke, and the smoke made her ill. Why isn't that competent?
Because we don't know what the nature of the illness was. And we don't know that there's any causation.
I'm not sure I agree with that at all, counsel. I think you have a tighter view of what the evidence would need to show than I do. I think that the case that was presented, if uncontroverted, showed a nuisance. You say I controverted it. I say it was interesting to me that there was less of a controversy than I expected. I'm going to read the papers again. I'm going to review the materials. I'm going to take the matter under advisement. I appreciate both of you and your professionalism. Thanks very much.
Your Honor, I'm sorry, but if I may, on the issue of contravention, in order for that evidence to be directly controverted, I would need to be able to cross-examine Mr. Ilios, and that was not, without an evidentiary hearing, that
I
wasn't.
understand your point to some extent, counsel. I understand your point to some extent. You're not on the property of the plaintiff where they're talking about what's going on the property. I understand that. However, you are very conscious of what's leaving the property boundary of your own clients. So I need to read it again with an eye toward what you folks have said. I thank you very much, and I'm going to end the hearing now.
Can I just respond to that last point?
I'll give you your last word, but that's it.
Yeah, I was going to say, counsel didn't ask for expedited discovery. He didn't ask for a hearing. If he wanted to controvert that stuff, there's procedural ways for him to do so.
Well,
He didn't ask for any of it. That's all I was saying.
It's not all his fault though, since you have the burden of proof, okay? I mean, you ultimately are responsible for an injunction that can stand up on appeal. And at this point, we don't have any findings from the judge. So that's where we are. Thanks very much, guys. We'll talk.
Thank you, Your Honor.
Thank you, Your Honor. Have a good day.
Yep. Bye.